Yeah. Where's this? Yeah, there. What's that?
As a court, please, my lord, we confirm our appearances on behalf of the state.
Okay. In the court, my lord, I am still confirming my appearance on behalf of Mr. Spi and Mr. Mngube.
Thank you.
This is the court, my lord, I still confirm my appearance on behalf of accused number 4, Mr. Mapisa.
Yeah, Bo.
Lord, I confirm my presence on behalf of Mr. Duli.
Yes. Yeah, so who's on the go now?
My lord, it is my turn today to argue the matter on the
Yeah.
application by the state.
Oh, okay.
My lord, from the onset, may I state that the issue for determination in this matter is whether the state can lead the new information at this stage, that is the stage when it is supposed to resume the cross-examination of this witness, Mr. Mngube. It is my submission, my lord, that if the answer is to the affirmative, I submit that that will encroach on the witness's right in terms of Section 35 of the Constitution. My lord, I must pause there and mention that it is not the first time that the defense is confronted with new information. I may highlight, my lord, the information regarding the statement of Constable Zongo, which was handed in as Exhibit AAA of the record. The photos which were handed in as Exhibit S of the record, as well as the Section 205 cell phone data of the witness, Mr. Mngube, which was handed in when the matter was still proceeding, not at the onset of the trial. Now, the defense or the witness is being confronted with the new information, which is the Section 205 cell phone data of the number ending 821, which belonged to Mabongo Ntoli. I submit, my lord, that this has been happening for a while now, and it encroaches on the accused's rights in terms of Section 35, subsection 3I of the Constitution of the Republic of South Africa, and it is the duty of the court to stop that from happening. My lord, I think it would be important for me to mention or remind the state of what happened in these proceedings on the 14th of August 2022, when I attempted to make an application before this court for the affidavit of the deceased witness, Mr. Thabang Makeleni. The state opposed my application on the basis that I did not follow the rules. I had to call the two witnesses, the police officers who commissioned the two affidavits of the witness, Mr. Thabang Makeleni. The state indicated that it was not enough for me to satisfy the jurisdictional requirements of Section 3 of the Law of Amendment Act 45 of 1988, and as such, I need to do more by calling the police officers who commissioned the two statements. Those officers are Captain Motwedi and Captain Mteto. Coming back, my lord, to the issues in this matter. The gravamen of the state submission, my lord, is that they are entitled to cross-examine accused number 3, Mr. Mthobisi Prince Mngube, using the cell phone data from the Cleveland case docket 92 of 2015. The state further submit that the contents of that docket was disclosed to the defense at the same time as the content of this main case, which is the phosphorus case 636 of 10/2014, were disclosed. The state, my lord, further submits that the investigating officer of that case, that is the Cleveland case 92 of 2015, had applied for the Section 205 cell phone data in terms of the provisions of Section 205 of the Criminal Procedure Act 51 of 1977 from Vodacom to establish the communication from the mobile number 072-7668-169 and other person, including Mabongo Ntuli, on the cell phone number 07914908821. The state, my lord, further contends that this cell phone data was always available in Cleveland case 96 of 2015. The accused confirmed under oath in his evidence in chief that he was with Mabongo Ntuli. It is then, my lord, what made us to be here today because of the sentiments by my colleagues, that is Dr. Sibanda on the 17th of August 2026, where he said the following, and I quote, "The state has decided to verify the movement of Mabongo Ntuli as per the tower information for the cell phone number 07914908821. The state assessed this set of data from Vodacom after the proceedings were adjourned on the 17th of August 2026, and it now intends to cross-examine accused number 3 as a witness, Mthobisi Prince Mngube." Close quotation. Dr. Sibanda further submitted, my lord, that there is an affidavit of the investigating officer where he makes an application in terms of Section 205 of the Criminal Procedure Act 51 of 1977 for the cell phone records inter alia for the cell phone number 07914908821. I must bring to the attention of the court, for the court's convenience, my lord, the provisions of Section 205. What do these provisions entail? Section 205 of the Criminal Procedure Act 51 of 1977, the Act, my lord, empowers a judge, regional court magistrate, or a magistrate to compel any person who has material or relevant information about an alleged offense to appear before them for examination. It is widely used by prosecutors and police as investigative tool to obtain confidential records such as banking statements or cell phone data. I note the crucial questions that follows after this is as follows. When was the request, my lord, made by the investigation officer of that Cleveland case? What does his affidavit accompanying his request and the basis for that request or information entail? A judge or magistrate who signed a request? Who is the employee from the service provider who analyzed and compiled a cell phone data? And when was this cell phone data generated? That is the cell phone data that the state is said to be in possession of. It follows, my lord, therefore, that without these processes and procedures, and ultimately an employee from Vodacom being called as the provisions of Section 205 of the Act requires, it remains hearsay. As the authors, my Lord, B.T. Zeffeld and A.P. Pierces, in subsequent law of evidence, define hearsay as follows, and I quote, "It is evidence, whether orally or in writing, the probative value of which depends upon the credibility of any person other than the person giving such evidence," close quotation. I will anchor the sentiments by my learned colleague, Mr. Ramsepele, to the effect that the state has to lead the evidence in the form of witnesses. And it has come to light, my Lord, that one of the witnesses, Mr. Mabongo, is deceased. So we don't know.
Sorry, when did he die or decease?
I'll have to take instructions, my Lord, but
I see.
I'll have to take instructions, my Lord, in that regard. Is deceased in order to prove that it was Mabongo Ntuli who was using this number ending 821. The state will have to make an application in terms of Section 3 of the Law of Evidence Amendment Act 45 of 1988. So it remains, my Lord, hearsay evidence in the absence of the witnesses such as the investigation officer, who is going to tell us in detail, my Lord, why he had to apply for a Section 205 cell phone data for the number ending 821. It doesn't end there. We also need to see the subpoena in terms of the Section 205 of the Act. We need the employee from the service provider. It could be Vodacom or MTN. And the experienced police officer, as my learned colleague, Mr. Ramsepele, indicated yesterday, of which I fully agree. An experienced police officer who has experience in the analysis of the cell phone data, that is the Section 205 records. So without this, my Lord, I submit with respect that it remains hearsay evidence. I must reiterate that, my Lord, that without the evidence of when a request was made, by whom it was made, the investigation officer who made the request, the reasons for the request in an affidavit dealing with the reasons for such a request, an affidavit from the employee of the service provider, it could be Vodacom or MTN, and the Section 205 cell phone data for the number 079-1490821, that information remains hearsay evidence without prima facie proof of the contents thereof. It remains hearsay, my Lord, because there is no evidence from the employee of the service provider to authenticate the contents of the Section 205 cell phone data. It is not enough, my Lord, for the state to say that they phoned Vodacom and received the Section 205 cell phone data, in brackets, records. They must do more, I submit, by calling the witnesses. As I've indicated, my Lord, from the onset, that I wanted to bring my own application in terms of Section 3 of the of the Law of Evidence Amendment Act 45 of 1988. I was advised by the state that I need to do more by following the rules, calling the two police officers to authenticate the statement of Mr. Mageleni, the deceased witness. I submit, my Lord, that similarly here, what we are faced with, the state cannot just confront this witness without calling the witnesses, more so the witness from the service provider who's going to authenticate the cell phone records. My Lord, the constitutional provisions in this regard are clear. Section 35, subsection 3, small letter B in bracket and small letter I in bracket of the Constitution of the Republic of South Africa, Act 108 of 1996, provides that every accused person has a right to a fair trial, which includes the right small letter B in bracket, to have adequate time and facilities to prepare for his defense. Small letter I in bracket, to adduce and challenge evidence. We see this, my lord, at this stage that the state wants to confront this witness, Mr. Mncube, on the contents of the Section 205 cell phone data. When did he get time to prepare with his legal representative, Advocate Mnisi, to prepare and have sufficient time to prepare for his defense in relation, my lord, to the Section 205 data, that is the record of the number ending 821, that the state is saying it is in possession of? If this perpetuates, I submit that it will amount to the violation of the accused's rights in terms of Section 35 of the Constitution. My lord, it doesn't end there. He still has to adduce evidence and challenge this evidence. When is he going to challenge this evidence? When he's just confronted for the first time with this information in cross-examination. My lord, I wish to pause there and respond to the state submissions in their heads of arguments. They have written, my lord, on the subject of cross-examination, and I think it amounts to about 2 pages. The defense, my lord, is not saying that the state is not entitled to cross-examine this witness. One must remember, my lord, the authorities. One that comes into mind at this stage is the state of the South African Football Rugby Union versus the President of the Republic of South Africa, where it was said that the institution of cross-examination is a right which is incumbent to any defense counsel, either for the state or for the defense. I must also re-emphasize, my lord, that the institution of cross-examination is the greatest engine ever invented for arriving at the truth. So one cannot deny the state at all to cross-examine this witness. But what we are saying is that the stage at which the state wants to embark with that procedure would violate this witness' rights in terms of Section 35 of the Constitution. I must also, my lord, remind the state that, and agree and applaud them for quoting the record to the following, my lord, at paragraph 5.1 of my heads of argument. The cross-examination of Constable Zungu by Advocate Nxumalo, record dated 2 October 2023, page 5, line 2 and lines 15 to 19, where a proposition was made to Constable Zungu that Mapung Ntuli was a person who was taking the photo on page 47 of Exhibit S at Lesedi Phosphorus. With the exception of Section 205 cell phone data for accused number 3, which was disclosed by the state after Constable Zungu had testified. That is my own emphasis. At 5.2, my lord, I indicated what the state cited in their heads of argument to the following. The cross-examination to Ms. Pinky Faitelingam by Advocate Nxumalo as per the record dated 24 July 2024 at page 80, lines 10 to 25, to the effect that a photo on page 9 of Exhibit S was taken on the 26th of October at 11 hours 52 minutes. The photo was taken at Mazibuko Hostel at Spruit in Katlehong, and the person who was taking the photo was Mapung Ntuli. 5.3. The cross-examination of Ms. Pinky Faitelingam by Advocate Nxumalo, record dated 24 July 2024, that Mapung Ntuli is mentioned as one of the occupant of a minibus Kumbi with accused number 3 in bracket Mncube and accused number 4 in bracket Mapisa. And that other person when they departed on the morning of the 26th of October 2014 from Johannesburg to Mazibuko hostel in Spruit. Therefore, my Lord, I submit, it cannot be said that the extracts of the record constitute new evidence. It has always been accused number 4's version as extracted from the record that I've referred to. It is the evidence of Constable Zungu and the evidence of Miss Pinky Faitelingam from Vodacom. I will now, my Lord, move on and discuss under the topic, the new information for the cell phone data. The state, my Lord, submits that on the 17th of August 2026, the state decided to verify the movement of Mapung Ntuli as per the tower information for the cell phone number 079190821. The state assessed this set of data from Vodacom after the proceedings were adjourned on the 17th of August 2026, and it now intends to cross-examine accused number 3, Mr. Mtobisi Prince Mncube. I submit, my Lord, that it cannot be correct, and it is not true that the state only realized that there was this information that they wanted to follow up on the 17th of August 2026 for the first time. I submit, my Lord, and encore the submission by my colleague, Mr. Ramsepele, that this information has always been there since 2015, as it relates to the 2015 incidences. I further submit, my Lord, that this was, as Brigadier Kininda wants to believe, that this was a procedural-driven investigation. In this regard, my Lord, the state had all the resources and all the information that they wanted to gather, and they did so. I'm saying this, my Lord, because of the following.
kuyiwona abhala ke lapho noma ke futhi ase beka ke istamp khona lapho. Ngahloma imibuzo kuyena ke uMncube ngecala leli ke noma ke idokodo lase Cleveland ushilo ke futhi noma ukhotile ukuthi ke abashushisi bashilo ukuthi kune statement esifungelwe sakhe umphenyi wecala noma ke umseshi la khona ke bathi ke wenza isicelo sawo ama cell phone records akho mabhungu. Umbuzo ke obuzwayo noma ufanele ubuze ukuthi ke isicelo leso senzwa nini uyena ke umphenyi wecala kulona icala lelo lase Cleveland. Ukhona yini umuntu osebenzayo lapho kwa Vodacom owabizwa ke noma ke owacwaninga lokho wase futhi ke ehlanganisa leyo mininingwane leyo. Uma ngabe ke impendulo lapho ke noma ke impendulo ingatholakala okusho ukuthi ke lokho kuyinzwa bethi ngoba ke akekho umuntu oqinisekisayo. Nokuthi ke kufanele futhi babize ofakazi nanjengoba eshilo umnumzane kaMsipile ngaphambi kokuthi ke bakuhloma imibuzo ngalo udaba lo abafisa ukuhloma ngalo kufanele ukuthi ke kube nofakazi abezayo ke la enkantolo abezokuthula ke ubufakazi lobo. Kufanele kubonwe ke incwadi eyaphuma ke enkantolo ebabizayo noma ke ebiza ofakazi umsebenzi ke osebenza khona ke eVodacom. Uma ngabe ngatholakali ke kube yiphoyisa ke lemkantsho ibomvu elinolwazi ke lwawo lomsebenzi. Uma ke lokho kungekho okusho ukuthi ke konke lokho kuyinzwa bethu. Ngaphandle kokuthi ke kutholakala ukuthi ke isicelo lesi senziwa nini senziwa ubani nomuntu futhi ke osebenza khona ke eVodacom okusho ukuthi ke akusiyona ke into inkantolo leyo esengayilalela kungasibona ke ubufakazi. Akwanele ukuthi ke abashushisi basho ukuthi ke bafone noma baye baxhumana no Vodacom base bethola ke imininingwane phecelezi ke idata lena bafanele ke ukuthi ke benzeke nangaphezulu kwalokho babize ofakazi. Abakwazi ke ukuthi ke bangathi bahloma imibuzo kuyena ufakazi oseboxini manje ngaphandle kokuthi ke ofakazi babizwe ukuzoqinisekisa lokho abathi bona banako bakutholile kwa Vodacom. Umunye umbuzo futhi okufanele ubuze ukuthi ke ngabe ufakazi yena ke uMncube ube nesikhathi nini esanele nini sokuthi ke ahlale phansi nommeli wakhe beyilungiselela ke ukuthi ke bazoyiphendula bathini ke kulona udaba lolu umbuso ozanalo. I-information lena ke kade ikhona nanjengoba naye ke umnumzane kaMsipile eshilo ukuthi ke ukusuka ngaye u2015 noGininda washo ke uma ngabe uyithola ubufakazi la enkantolo ukuthi ke uphenyo ababelenza uphenyo ke olwaluholwa ibona abashushisi. Ingabe abashushisi babekhohlisa noma bedukisa inkantolo yini ngesikhathi ke babetshela noma besho ngaye uStain ukuthi ke inamba le ekukhulunywa ngayo la inamba yakhe umsola wesihlanu kwase kuba ke noma ke kwase kulungiswa ke lokho khona la enkantolo betshelwa ukuthi cha kusona inamba yomsola wesihlanu kodwa inamba yakhe uMabhungu Ntuli. Asazi ke noma angazi ukuthi yini ke eksona istatement lesi esifungele abakhuluma ngaso asazi ukuthi yibani uyiphi imantshi eyavumelana ke naso isicelo leso esenziwa noma ke umuntu osebenza kwa Vodacom. Kunama page ke awu6 akhulume ngawo advocate uNqumalo athi ke ayo imininingwane yale number egcina ngaye u821 upage 1 kuyofica ke ku7 abekho asazi ke noma ke kwenziwe ngenhloso yini ukuthi lawo ama page lawo akhishwe. Umfuthi ke umaphisakaze akhuluma ngamabhungu athi ke uMabhungu ke ila ayekhona noma ke athi uMabhungu umuntu owayendawonye naye kodwa ke wayethula nje inkulumo yakhe kofakazi ukuthi ke yena ke uthini ngokuhlangene naye uMabhungu. Isicelo ke sokuthi ke inkantolo lesicelo lesi ke noma ke uthi ummeli inkantolo ayingazivumi ke lesicelo siza nabashushisi ukuthi ke balethe ubufakazi obusha bakubuze ngabo. Yase ke inkantolo sibacela ukuthi ke kunamacala ke acelayo ukuthi ke bahambe baye bafunda noma ke izinqumo ezenziwe ke inkantolo ukuthi ke ahambisanayo ke nalesicelo lesi inkantolo ebhekene naso njengamanje ukuthi abameli kanye nabashushisi bahambe ke bayofunda ukuthi inkantolo zithini lapho.
Thanks. Yes, Mr. Msholo, let's hear you.
I'm surprised this lordship jumped me when he asked my colleagues whether
What's that?
I'm surprised that you jumped me, my lord.
Jumped.
Yes, when you asked my colleagues whether they know those two cases that we referred to.
Oh, I jumped you. Sorry.
Yes, I'm
Sorry.
a working library, my lord.
Okay. Sorry. I'm sorry.
Yes, I'm a working library.
Okay.
Masua, my lord,
Yeah.
by the learned Justice Spill.
Spill. Yeah.
It deals specifically about Section 186 and 167.
Yes.
It was a road rage incident, and there was an operation of a bike involved by the deceased.
Yes.
And the learned colleague here, Lieutenant Colonel Mangena's evidence was questioned by the judge, who requested the leather jacket that was worn by the deceased to be displayed at court because there was political issues relating to that, and also regarding the operation of the motorbike, because the judge said, my learned assessors do not know perhaps about motorbikes, but the judge knows about motorbikes, so he can take judicial notice of that. So I'm surprised when it is linked to cell phone evidence, my lord. The other
No,
matter,
it's not linked.
yes,
It's the principles.
the principle.
That's all, that's
yes, yes.
That's the principle, because as you know,
yes,
the court, and please, I mustn't be misconstrued as saying I want to assist A or B.
yes,
Please, because Spill, as you read,
yes,
is at pains to say the court must strive, despite what the other parties may think,
yes,
to be neutral in this matter and to facilitate the hearing of this matter with the rearguard that justice should be done.
yes. I
That's
remember
all, that's
because
all.
there was a to and fro between
That's it, yeah.
the defense and the state, whether the court should have
Yeah.
informed the parties that it wants to invoke 186,
That's it.
167. But eventually the court said,
Yeah.
I'm here to assist
That's it.
the case, not both sides.
Yeah,
man.
there's even that
I'm
case
very
of
well aware of that case.
There's even the case of Gerber,
Yes,
to say that it is not humanly possible, maybe, for a judge not to be accused of favoring A or B.
yes. That's the court decision.
But you know what? I think, Mr. Mshololo, sorry about that. It's your turn. I wasn't saying, hey, ubana ngaifundanga. It's good that you have read it, because me, I'm also a working library. Yes, you may address me, sir. I mean, madam.
Thank you, my lord. My lord, if I may start answering the court's question that was posed to my learned friend, Advocate Ngomalo, to
Yeah.
say, if the court were to allow the state to do what we are saying they have not done. That's the main problem that we are sitting with.
Yeah, quite.
That the state cannot be able to do that at this stage.
Oh, fine.
Because accused number 3, specifically, my lord, when he started testifying, he was not aware of the evidence that the state intends to introduce now.
Okay.
That is why we are dealing with this application. And my lord, I would like to thank the court for giving us the opportunity to make submissions and also to research on this. Because we have discovered that it is misleading what the state said yesterday in the opening submission to say it's just a matter of courtesy to inform the defense of what they're intending to do. No, it's a constitutional right that the state intends to violate. And the case law that the state has referred to, my lord, I'm going to make reference on it extensively, that whenever the state or a new evidence needs to be introduced during trial, there are certain requirements that needs to be met. It's not an automatic right. It doesn't come as an automatic right because in Mulala's case, the new evidence was allowed in the SCA. Therefore, in this case, the state has to be allowed to introduce new evidence at this stage. When accused number 3 has already testified, my lord. When accused number 3 was preparing his case, he was not aware that the state will be using the cell phone records for Mr. Mabungundulu. That is not allowed in law. And I like the question that was posed by his lordship to the state when they firstly indicated that they want to do this. And the court said, are you allowed to do that? My Lord, my submission is that the state is not allowed. And I'm going to address his lordship. Why am I saying the state is not allowed? And I'm objecting to that procedure. And my Lord, if the state were to be given that opportunity to do what we are saying they have not done, how is that going to be done? Because accused number 3 is testifying.
Is what?
Accused number 2 is at is cross-examination.
Yeah, so fine.
Yes. Therefore, my Lord, that's why I'm saying that there is a problem, because all those witnesses, the evidence regarding the circumstances under which the Section 205 records for Mabungu Ntuli that the state intends to lead has not been led before this court. It does not form part of the record, does not form part of any of the exhibits that have been submitted in this court. It's a new evidence. My Lord, can I just beg leave to give the interpreter this transcript for the 28th of August, 2023. In other words, my Lord, my submission is that even if the court were to allow the state to introduce new evidence at this stage, but it has to follow the relevant authorities. And my Lord, the relevant authorities, I am making submissions to this court. Is 1, S versus D. Jager, Jager. There are many cases, my Lord, that we can refer his lordship to, but I've just pointed these 2, my Lord. 1965, Volume 2, SA 612, Appellant Division at page 613. The judge in this case, my Lord, says to introduce a new evidence during trial or at an appeal stage. It's an exceptional thing, it's an exceptional circumstance that can be done. And the person who intends to introduce evidence during trial has to meet the certain requirements. And one of them, my Lord, in paragraph 9 of the Mulali case, Mulula, my Lord, it's not Mulali, Mulula case, it's an appellant division as well. It has been quoted by the state in their heads of argument. Paragraph 10, the court says, according to this court, has over a series of decisions worked out certain basic requirements. These are summarized in S versus D. Jager, 1965, Volume 2, SA 612, Appellant Division at paragraph 613. 1, there should be some reasonable sufficient explanation based on allegations which may be true, why evidence which is sought to be led was not led at the trial. So the principle, my Lord, I am inviting this court to apply is the same as this one.
Yeah, no, thanks. Thanks for that, and I'm aware of that.
Yes.
But another thing maybe which may escape some of us.
Yes.
It's Section 183.
Yes, my Lord.
Are you with me?
Yes, my Lord.
Yeah.
Yes. Because as I'm...
Section 183 and 167.
Yes, my Lord. Because...
Which are resident in the discretion of a court.
Yes, yes. My Lord, also, even if the court were to apply the discretion, now that we have been invited to make submissions, I think it is fair, my Lord, that I make the submissions, then the court can apply the discretion.
No. Be at ease. Do what you have to do.
My submission, my lord, is that the state has not complied with this requirement.
Yeah, fine.
We have not. In their heads of arguments, my lord, in their submissions, we have not been advanced with the reasons as to why this portion of evidence that the state intends to lead now during cross-examination of accused number 3 was not led. The second one, there should be a prima facie likelihood of the truth of the evidence. My lord, I am going to show the court when this evidence emanated from. And from the written heads that have been submitted to the state, they are making references to the versions that have been put to the witnesses in paragraph 2.8 of the state submissions, that there have been referrals that have been made by my learned friends, Advocate Ngumalo and Advocate Mnisi, respectively, regarding the position of Mr. Mabungu Ntuli on the 26th of October 2024. Those versions have been placed before this court. But the state failed to introduce the evidence of the cell phone records for that person who is Mabungu Ntuli at that time. And it's only now when the accused number 3 is testifying, the state says, oh, now we want to introduce this evidence. And I further submit, my lord, and want to bring it to the attention of this court that the section 205 for Mabungu Ntuli, as my learned friend has made submissions on Tuesday, said they have been able to retrieve it from another case, which case is not before this court. Here we are dealing with the case of phosphorus, case number 636, not Cleveland, not Alexandra, not any other case. And above that, my lord, we have, the accused are entitled to know the circumstances under which this cell phone records for Mabungu Ntuli was obtained, because it was not obtained under this case. It was not obtained by the people who were investigating this case that this court is dealing with. The third requirement, my lord, in this case, it says the evidence should be materially relevant to the outcome of the trial. Hence, I'm making submissions, my lord, to say we do not know the circumstances. We do not know what type of the Section 205 records that the state intends to do. In other words, it means if there is no consent to the submission of the Section 205 records for Mabungu Ntuli, it means the state has to lead evidence regarding that. And it's not submitted on the mere production, my lord. Section 205 records is not admitted on its mere production, my lord. There is a procedure that needs to be followed if one needs to lead that evidence. And I will not want to waste the court's time explaining where it starts, from the investigating officer to the magistrate to the last person who produces the Section 205 records. That has not been placed before this court. That's the evidence that is not before this court. And the court has to weigh the evidence that is before it because it complies with the requirements for the admissibility of evidence. Section 205 records cannot just fly into the record by the state to say we're now introducing the Section 205 cell phone evidence for Mr. Mabungu Ntuli. It doesn't happen like that, my lord, and that's not the process and the procedure in law that is acceptable. Even if the court would like to exercise its discretion, but the court is bound by these basic principles of evidence, how the evidence is admitted in a court of law. The cell phone records, the mere fact that the state has it, cannot just hand it to the accused to say, can you answer on these cell phone records? It has to be placed, the evidence has to be placed properly before this court, which is not before this court. My Lord, the interest of justice, after looking at these requirements that I have referred the court to, which are stated in the case of Ace versus DJ, my Lord, it is my submission that the state has failed to comply with those requirements. And the reason, my Lord, my first reason, it's on the evidence of Colonel Stein, which was led on the 28th of July, 2023. The reason why I am bringing this to the attention of the court, my Lord, is to show the court that it is not true, my Lord, that the state only became aware of this evidence when accused number 3 was testifying. It's misleading, my Lord. Transcript 28 of July 2023, on page 2. My Lord, this is the evidence of Colonel Stein on paragraph 10, wherein, my Lord, reads as follows. Did you get it, Mr. Johnson?
July or August?
28 July.
Here it says 2808. Okay, but it's
2808?
fine, you can read. It says 2808.
Page 2.
Page 2, 28.
Can I double check? Maybe it's the wrong one. My apologies, my Lord. No, sorry, my apologies, it's the wrong one. Can I just read you? You will interpret as I read into the record. Yes, thank you. I'm reading from the transcript of 28 July 2023 on page 2, paragraph 10. Mr. Stein, and we refer to him as suspect 5. According to all the downloads, he is using 6 different numbers that I determined by means of the people who knows him saved his name on their contact list. The following numbers belong to him, suspect number 5.
Lobufakazi buka Colonel Stein abufundayo ke advocate ukuthi ke simazi ke nanjengomsola wesihlanu futhi ke le number lezi eziyisithupha ke eziwu6 inumber ke ayisebenzisayo sikwazi lokho ke ngenxa ke yabantu ke abasave ama number akhe noma ke abamsavile kuma phone abo.
The first number is 072 399 5787.
39957 87.
87, yes.
Yes.
The second number is 07914900821. The one that we are dealing with, my Lord, now. According to Stein, he says it was saved from accused number 5 list. The next number is 0766 427007. The next number is 071 302 9173. The next number is 076 97 35 176. The last one, 076 97 35 176.
I've got it. So It's 5 numbers.
It's 5 numbers? Yes. Then I will move to the Mikli, to that one suspect number 5, with number 0733059202. Did make contact with suspect number 3 with the name of Mthobisi Gadla Mncube.
Lama number ke awaqeda wafunda uadvocate wona ka number athi ke kubufakazi bakhe uSteni washo ukuthi ke ama number kaMnumzana uNtuli lama number akalandelayo 072 399 5787 079 1490821 iyona ke le inumber ekukhulunywa ngayo njengamanje uSteni ke awasho kubufakazi bakhe ukuthi ke inumber leyo ke yakhe umsolo wesihlanu 0766 427 007 302 9173 076 973 5176 bese kuba u07 33059202 tike inumber leyo ke ngokufakazi bakhe ke uStain axhumana nayo ke noma ayisebenzisa uxhumana naye umsola wesithathu uMthobisi Gadla Mncube.
Yes. My Lord, Colonel Steyn, when he was testifying in this paragraph 10, he says, according to all the downloads, he is using 6 different numbers that I have determined by means of the people who knows him, saved his name on their contact list, including this number that the state intends to introduce its Section 205 records at this stage. So the state was well aware. The state knew about this number as early as 28 July 2023, before the state case was closed. That is when the state had an opportunity to lead the evidence of the cell phone records belonging to any of this number. But the state failed to do that. And then I move on to page number 4, my Lord, of the same transcript, 28 July 2023, paragraph 10 as well. It's also Colonel Steyn. The next number I retrieved from the download of suspect number 3. The number was saved on his phone as Vugani Kumalo, but the number also belonged to suspect number 5. Then I moved to this number down here. This is another number of suspect number 5 with the number 079 1490821.
Uyaqhubeka ke kule page uKenya Steyn uyasho ukuthi ke le number lena ke yayisave kuona ke noma ngayithola kuona ama download akhe umsolo wesithathu le number yayisave na njengovukani Khumalo inumber lena ke ku 0791490821.
Then I moved down straight, I'm reading from the record, my Lord. Then I moved down straight underneath that number of suspect number 5, meaning 07914900821. Colonel Steyn says it's for number 5, that number. That now the state says it's for Mapunguntuli, and they want to introduce that cell phone record. Colonel Steyn says the number of suspect number 5 also got contact with suspect number 2, Bongani Sandi Sontanzi, with number 076 09016890.
Qhubeka ke uKenya Steyn esakhuluma ngayo ke le number lena u0791490821 ethi ke inumber yakhe umsolwa wesihlanu ukuthi ke yaqhubeka nako nokuxhumana naye ke umsolwa wesibili uBongani Ntanzi ku 076090168990.
Colonel Steyn further says, in the same number, the one there on top, I moved to this number down here now. Suspect number 5 also got with suspect number 1, Sitembe Sibia alias Muzi, with cell phone number 07937901137. So in other words, Colonel Steyn, my Lord, in this evidence is saying, accused number 5, using the number 07914900821 that the state intends to introduce the cell phone records, communicated with Moses Sibiya, which is accused number 1, using the cell phone number 0793790137. And the reason why I'm bringing this to the attention of His Lordship, my Lord, is to say the state was well aware of this evidence. And Mr. Kenneth Stein is saying the accused were communicating using this number. Then why then the state did not bring? Why it didn't come to the attention of the state that this number is so crucial that the section 205 records of this number should be placed on record? Now that there is a contradictory evidence that the state is faced with, they now want to introduce the section 205 records. We need to continue with this evidence of Kenneth Stein. He's a state witness, my lord.
Phindile-ke kuyona le number lena eku 0791490821 washo uKenneth Stein ukuthi yaba nokuxhumana naye-ke 07937900137 number-ke kamsolo wokuqala uSibiya. Lapho-ke abashushisi into lena abebekade beyazi-ke ngaso sonke-ke isikhathi kungani-ke lokho kungabafikelanga ngalesiya sikhathi-ke, kodwa manje nanjengoba manje sekukhona-ke ukushayisana-ke ubufakazi obukhona, ingakho-ke manje sebeletha ubufakazi lobu, futhi-ke kufanele siqhubeke-ke nalokhu ngoba-ke uKenneth Stein ebewufakazi bezokuthula ubufakazi la phambi kwayo lenkantolo.
Okay, you say it's past tea time.
Thank you, my lords.
Yes, Mr. Cholo.
Thank you, my lord. My lord, I was on page 5 of, reading on page 5 of the same transcript record dated 28 July 2023 under Mr. Baloyi, which is line number 18. Mr. Baloyi asked Colonel Stein, just before you proceed, Colonel, the person that whose number appears as 079-1490821 Mabungu Ntuli, you are linking to accused number 5. Can you just explain? Should I repeat? Yes. Okay. I'm reading on line number 18 of the transcript dated 28 July 2023. Mr. Baloyi, under Mr. Baloyi's examination in chief, just before you proceed, Colonel, the person that whose number appears as 079-1490821, Mabongo Ntuli, you are linking to the accused number 5. Can you just explain?
La afunda khona ke advocate kwaku advocate uBaloyi ebuza yena ke uKenneth Stein ukuthi ke la ufunda khona 0791490821 Mabungu Ntuli uthi ke leyo number leyo ke uyihlanganisa nomsola wesihlanu ungachaza nje.
Yes. So in other words, my lord, it means that the state was aware of this number as early as 28 July 2023.
Bange 28 July 2023 usho ukuthi ke abashoshisi ke noma umbuso ke wawunolwazi lwayo inamba lena.
Though Colonel Stein refers to it as the one of accused number 5, but Mr. Baloyi, Advocate Baloyi here, is just referring Colonel Stein as he says, just before you proceed, Colonel Stein, that whose number appears as 079-1490821 Mabongo Ntuli, are you linking to accused number 5? Can you just explain?
Nanoma yena ke uKenneth Stein wayethi uma ichaza ke ngale number athi ke inumber ayihlanganisa nomsola wesihlanu kodwa ke yena uadvocate uBaloyi embuza ke ethi inumber lena ke 079-1490821 Mabungu Ntuli wena uyihlanganisa nomsola wesihlanu.
Until it was further rectified and confirmed that the number belongs to Mabungu Ntuli.
Kwaze kwayilapho na ke manje sekulungiswa ke lokho ukuthi ke kwaqinisekiswa ukuthi ke inumber leyo uyinumber kaMabungu Ntuli.
On page 6, my lord, that's my last extract that I'm going to read from this record. On page 6, line number 9. Mr. Baloyi, may just before you proceed giving this picture, is there an indication as to who the central figure is? Who the central person is? Mr. Stein, in response. It is not possible to determine. I can just determine that the suspect in front of the court, my lord, know each other. They did talk to each other, but if you look at suspect number 5 and suspect number 3, they did speak to each other. So I will say that is going to be according to my opinion.
Wasebuza ke advocate Baloyi buza ke na ke uKenneth Stein ukuthi ke ubani ke manje umuntu ke lana omaphakathi ke noma ke okuyena ke ohlanganisayo noma ke okuyena ohlanganisa izinto noma ke abantu wathi ke uma phendula uKenneth Stein angeke mina ngibeke isimo sokuthi ngakuphendula ke noma ngakusho lokho kodwa ke uma ngabubuka ke ungatsho nje ukuthi ke abasola phambi kwenkantolo bayazana noma uma ubuka yena umsola wesithathu nowesihlanu ukuthi ke uxhumana ukhona phakathi kwabo uvo lwami nje lolo.
So my lord, I submit that Colonel Stein even made an opinion based on this number.
Ngakusho ke lokho ukuthi ke uKenneth Stein unovo awalusho la enkantolo ngayo inamba le.
Based on this number 079-1490821 that the accused were communicating each other.
The number 079-1490821 ukuthi ke abasolwa babexhumana.
Therefore, it should have came to the attention of the state that this number is very important to request the Section 205 records of it at that time in 2023, my Lord.
ngakho ke into lena bakufanele ke ukuthi ke ifikile ke kumcabango wabo ke abashushisi kwangaleso sikhathi leso ngo2023 ukuthi inamba lena ke isemqoka ke kufanele ukuthi ke bacele ama section 205 ayo.
The state had an ample opportunity to lead this evidence of the cell phone records regarding this number.
Babe nethuba ke elanele lokuthi ke bangathi ke beze nayo ke imininingwane ama cell phone records ayo inamba lena.
And I repeat, my Lord, it is not true that the state became aware only during the testimony of accused number 3 of this number of Mabunguntuli and its communication with the accused.
Ngiyaphinda ukuthi akulona iqiniso ukuthi ke into ke abayazi ngalesikhathi umsolo wesithathu ke sethula ke ubufakazi lana inamba lena ke nokuthi ke kwakhona ukuxhumana kanye nabo abasolo.
The accused, my Lord, okay, before I move on there, furthermore, my Lord, as I have indicated in my heads of arguments, paragraph 8, maybe if I can start on paragraph 5 and paragraph 6, my Lord, to add on what I have referred this court to the transcript of the evidence of Mr. Stein, that the state was well aware of this number and the issue of Mabongo Ntuli and the communication of Mabongo Ntuli. It is considered by the state in paragraph 2.81 that it was posited to some of the witnesses that accused number 3 and 4 were with Mabongo Ntuli and other people in a combi where they drove from Johannesburg to Spruit at Mazibuko Hostel. It is submitted that the state ought to have introduced these cell phone records of Mabongo Ntuli at that stage if they wanted to rebut that evidence, but not to wait for accused number 3 to testify. Actually, accused 1, 2, and 3, my Lord, to testify, and only then state intends to bring this evidence. And further, in paragraph 6 as well of my heads of arguments, my Lord, further, the state in paragraph 2.8.2 of their heads of arguments refers to propositions made by Advocate Ngumalo to Constable Zongo about Mabongo Ntuli, who took pictures on Exhibit S. Again, the state failed to introduce this evidence of cell phone records for Mabongo Ntuli.
Masifunda lana ke state bayavuma ke abashushisi noma umbuso ke ku paragraph 2.8.1 ukuthi ke kwaba yinkulumo ke lena noma ke kwashiwo ke kwabanye ofakazi ukuthi ke umsolo wesithathu nowesine babe ndawonye noMabongo Ntuli kanye futhi nabanye abantu kwitekisi la abahamba khona ke besuke eGoli beya ke eSpruit eKatlehong eMazibuko Hostel. Nokuthi ke ubufakazi lobuke bakufanele ke ukuthi abashushisi babulethile ke bomakhalekhukhwini ngaleso sikhathi leso uma kuukuthi ke babefisa ukuthi ke baphikise ubufakazi, kodwa ke abazange bakwenze lokho base ke bangafanele ukuthi balindeke manje ngoba ke umsolo wesithathu azethula ubufakazi kanye nomsolo wokuqala kanye nowesibili. Futhi ke ku paragraph 2.8.2 kuzona ke izethulo zabo bakhuluma ke ngenkulumo enziwa uyena uAdvocate uNqumalo ku Constable Zungu ngaye uMabongo Ntuli owashutha izithombe ku Exhibit S, nalapho futhi ke abashushisi ke ababethulanga noma babelethanga ubufakazi lobo omakhalekhukhwini bakhe uMabongo Ntuli.
My Lord, it is my submission that it is not in the interest of justice to allow the state to cross-examine Mr. Mncube on the cell phone data and movement of the phone of Mr. Mabongo Ntuli, which was not led during the state case.
Kuzoba akwenziwa bona ke ubulungisa uma ngabe ke inkantolo ingathi ivumeleke ukuthi mshushisi ke ahlomeke imibuzo kuyena umnumzana uMncube mayelana ke nama records omakhalekhukhwini akhe umnumzana uMabhungu Ntuli.
Why am I saying that, my lord? Because Mr. Ntuli, when he was preparing his defense case, he was not aware that this kind of evidence, the Section 205 records of Mr. Mabhungu Ntuli, will be used. And he was not even aware that that evidence is before this court.
Kusho lokho ke ngoba ke umnumzana Ntuli ke ngesikhathi eyilungiselela ubufakazi bakhe ke wayengazi.
Mr. Mncube, sorry.
Okay.
When Mr. Mncube?
Oh, that's sorry. Umnumzana uMncube ngesikhathi ke eyilungiselela wayengenalo ke ulwazi lokuthi ke lobo bufakazi lobo ke bukhona ke noma ke ubufakazi lobo ke obuzothi ke abashushisi babulethe bamhlome imibuzo ngabo.
In terms of Section 35, subsection 3 of the Constitution, my lord, Mr. Ncube has got a constitutional right that is entrenched in the Constitution, which is Section 35, subsection 3A. Every accused person has a right to a fair trial. Mr. Ncube will not receive a fair trial by the inclusion of this new evidence at the time when he is in the middle of cross-examination by the state.
Lapha afunda khona ke advocate section 35 yasho ukuthi ke umsolo ngamunye ke unelungelo ke lokuthi ke icala lakhe ke liqulweke ngendlela efanele nekuyiyona angeke ke umnumzana Ncube abe necala ke eliqulwa ngendlela efanele nekuyiyona uma ngabe manje ke sekuzokwethula ke noma kulethwe ubufakazi lobo.
The constitutional right of Mr. Ncube that is entrenched in the Bill of Rights, my lord, further says, which includes the right, A, to be informed of the charge with sufficient detail to answer.
Lungelo ke lokuthi ke atshelwe ke ngecala alethweswayo nokuthi ke nemininingwane ephelele azothi ke aphendule yona.
Furthermore, my lord, I submit that it is the duty of this honorable court to see that justice is done as it is referred to in the case of R versus Hepworth.
Kukule nkantolo ke ukuthi ke iboneke ukuthi ngempela ke ubulungiswa buyenzeka nanjengoba ke icala lika Hepworth lisho kanjalo.
Wherein it says, my lord, the duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of the procedure, but to see that justice was done.
Eshoyo ke kulona lecala ka Hepworth ukuthi ke akusona nje ukuthi ke umehluleli ke asho ukuthi cha akwenziwe kanje akuyiwe ngale kodwa ke uqinisekisa nokubona ukuthi ngempela ubulungiswa buyenziwa.
My lord, the versions that have been put to the witnesses regarding the movement of Mabhungu and the other accused, they do not form part of the evidence of Mr. Ncube until it's confirmed under oath.
Inkulumo ezashiwa noma lokho ke okwashiwo ke kofakazi ke ngokuthi ke uMabhungu Ntuli kanye futhi ke nabanye abasolwa ukuthi babe kuphi bahamba baya ngakuphi ke ukuthi lokho ke akusibona ke ubufakazi obungaphansi kwesifungo kuze kube isikhathi la khona lokho kuqinisekiswa.
So the constitutional rights of Mr. Ncube to be furnished with sufficient detailed information to answer before he takes the witness box has been violated or will be violated by the inclusion of this evidence at this stage.
Ngokufakwa ke noma ngokulethwa kwalobufakazi ke ngaso lesigaba lesike noma lesikhathi lesike ila khona ke elizokudicilela phansi ke ilungelo lakhe umnumzana uMncube lokuthi ke anikezwe imininingwane eyanele ngamayela nalo icala.
Therefore, my lord, it is my respectful submission that this honorable court should rule in favor of the protection of the constitutional rights of Mr. Ncube.
Ukuthi ke inkantolo lena ke kuzofanele ke manje yenze isinqumo leso ke esizovikela ke ilungelo ke nanjengoba likhona kumthetho sisekelo ilungelo lakhe umnumzana uMncube.
Yeah, thanks.
Is the court, please, my lord, if we may be afforded the opportunity to reply.
Afforded the opportunity?
To reply,
Are you entitled to reply
yes,
in terms of our rules?
yes, we are, my lord.
Oh, yeah, by the way, yeah, okay, fine.
Yes. My lord, perhaps it's apposite to remind everyone as to why we are at this point. And the state simply gave an advance warning of its intention to cross-examine Mr. Ngube on the cell phone records of Mr. Mabungu Ntuli. And the simple reason that we did that, my lord, was to give everyone the fair opportunity to once again have a look at those cell phone records. We made them available, and my lord, we still make that offer to our colleagues, the defense, that they are available, and it would have been perhaps appropriate to first look at that evidence, determine as to whether it meets with the requirements as set out in the Electronics Communications Act, and then to take it from there, because the objections at this point, my lord, are very, and we're saying this with the greatest of respect, are speculative. I think the state should be allowed to proceed with the presentation of the evidence, to lay the basis for the evidence. Then my colleagues can then, at that point, if they, after having, if they want to avail themselves of the opportunity to peruse the cell phone records, if they want to take up any issue, then they can do it at that point. What is of a crucial importance, my lord, is to try and identify the type of evidence that we are dealing with, to categorize it appropriately, and in the case of Mohapi that Mr. Ramsepele referred to, this evidence was, cell phone evidence was characterized as real evidence. And we've been at pains, my lord, to indicate that the only test is whether the evidence is, if we are dealing with real evidence, is whether it's relevant. The issue of authentication comes only at the end of the case, when the merits are argued. We have previously referred to the case of State versus Balega and others. It's 1986, volume 4, SA 192, where the court ruled that the admissibility of videotape recordings as real evidence, and that determining the authenticity thereof do not affect admissibility, but rather the weight of the evidence, which will be determined at the end of the trial. And the same was also said in the case of ex parte Roche that advocate Mr. Ramosepele also referred to, the telephone records that were obtained from the hotel that the tourists were staying in were regarded as real evidence. And the court said the weight to be attached thereto will only be determined at the end of the case. So without rehashing our argument, my lord, the question at this stage is relevance. That is the point that we want to buttress. But furthermore, my lord, we are dealing with cell phone evidence, and in this regard, it's perhaps appropriate to refer to what the court said in Mohapi's case, that cell phone evidence stand on a different footing. The cell phone records are generated automatically by computer systems and network infrastructure rather than human observation or narration. That they speak for themselves. They are like a silent witness. That they don't constitute hearsay. And the court held that the focus should be on whether there is sufficient evidence to establish their reliability and integrity, and the manner in which they've been produced. And in this regard, my lord, we just want to focus on a few aspects that were raised by counsel. And regarding the aspects that were raised by Mr. Ramusepeli with reference to Mohapi's case, firstly, he correctly mentions that the objection is made in vacuum. Hence, we offer them the evidential material that we intend to use, so that if there is an objection, it must be based on fact, because as we pointed out, my lord, and we make this submission with respect that the objections are speculative. For instance, Mr. Ramusepeli pointed out that the jurisdictional factors mentioned in Mohapi's case, that there is uncertainty about that there's uncertainty about the certification of the cell phone records, that there's a certain uncertainty about the authentication of the call data, the uncertainty as to whether the Section 205s are based on Mr. Mabungu's Mabungu Ntuli, and that would amount to hearsay if human, if that was human created content. I'm just trying to summarize what he said, and that the state must first lay the basis for the evidence. And this, to a certain extent, was repeated by Mr. Numalo at paragraph 6.5 of his head, where he says that the state has submitted that it had an affidavit of the investigating officer. We do not know his name. We do not know what is contained in his affidavit in support of the application. We do not know the magistrate that signed the request. And lastly, but not least, we do not know who the employee from Vodacom that analyzed and authenticated the cell data. All these aspects, my lord, are indicative of the fact that perhaps all the objections are, with the greatest of respect, premature, that the state should first be allowed to proceed with the evidence, and then my learned friends can then at that point take any issue with the evidence that they might deem fit. Advocate Mshololo pointed out that how will or asked the question as to how will the state lead such evidence. Yesterday, when we're dealing with the purpose of cross-examination, you can still prove your case through cross-examination through the other party. So, in summary, my lord, you are saying that, and with the greatest of respect, that perhaps the cart is put before the horse. All these aspects that council are raising will be answered in the affidavit of the Vodacom officer. And this is the biggest difference between the current situation and Mohapi's case. In Mohapi's case, the affidavit of the Vodacom officer wasn't before court, even if the court then relied on the evidence of the other three witnesses. But in this case, we do have the affidavit of the Vodacom officer. All these issues that council are saying there's uncertainty about will be addressed in the affidavit. If we are allowed to proceed to present the evidence in terms of Section 15(4) of the Electronics Communications Act 25 of 2002, which state that such information is prima facie proof thereof until rebutted. So my colleagues will then have the opportunity to either challenge the evidence or call witnesses to challenge such evidence. Mr. Ramusepeli mentioned that if we establish these jurisdictional factors, to use his own words, we can have a field day with Mr. Ngube. And our submission, my lord, is that the affidavit, and we will lay the basis for putting up this affidavit. Once, if we cross that hurdle, my lord, all these issues that have been raised by council will be addressed. As we indicated, the defense will have the opportunity to challenge the evidence in re-exam, or they can call other witnesses to rebut such evidence. And none of the authorities quoted by my colleagues state that the state is debarred from cross-examining on such cell phone records. In Mohapi's case, the case concerned the weight to be attached to the evidence as an officer from Vodacom had not testified, and not relevance. As we indicated, my lord, we pointed out yesterday that at this stage of the proceedings, it is about the relevance of the evidence and not the weight to be attached to the evidence. The issue of weight will come at the argument stage on the merits. As Mr. Ramusepeli eloquently indicated yesterday, that in Mohapi's case, the appellants contended that the cell phone records relied upon by the state should not have been admitted, in the sense that no weight should have been attached to them because the state had not called a witness from Vodacom to authenticate them. However, as we indicated in appeal, the court was satisfied that the witnesses that were called have addressed, have sufficiently authenticated those records. And in our case, and we don't want to belabor this point, we do have an affidavit of the officer from Vodacom who will address all these issues that have been raised by counsel. The practical suggestion, my lord, that we offering, and that's what we suggested yesterday, and we repeat that, is that the state be allowed to proceed. The offer for disclosure still stands, and some counsels say they have received the disclosure, even if not complete, like Advocate Ngumalo, but others say, they haven't received the cell phone records. Now, to level the playing field, we're still prepared to make that disclosure so that we are all on equal footing. If they need time, we have never been unreasonable to oppose any request for more time. And then we be allowed to then proceed with the presentation of the evidence, laying the proper basis, and if counsel wants to raise any objection, they can do that at that point. And just perhaps one last aspect, Advocate Ngumalo mentioned the question of the two affidavits that he wanted to hand up, and is comparing that to the current situation. Our submissions that this is chalk from cheese. In the current instance, there's a specific legislation that deals with data of the nature of cell phone records, and that is prima facie proof of the contents thereof. And the court specifically, as we mentioned, said this is not hearsay evidence. So one cannot really compare the two situations. So in conclusion, my lord, the practical way of dealing with the matter is to, if my colleagues are still not interested in the disclosure, that the state be allowed to proceed with the presentation of the evidence, laying the basis, and my learned colleagues can then raise any objection that they wish to.
Ngiyaphendula ke umshushisi kwizethulo ke ezenziwe yibona abameli uthi ke ucela inkantolo ibheke lokho kulandelayo ukuthi ke kwaseqaleni ke abashushisi ke kunesixwayiso abanikeza ngaso ke sokuthi ke beyimisela ukuthi ke bahlome imibuzo ukuthi ke wonke umuntu anikezwe ke ithuba elanele nekuyilona ukuthi ke bawabuke noma bawabheke ama records kubukwe bona ke ubufakazi ukuthi ke buyahambisana yini ke naloko okulindelekile phecelezi ke ama requirements. Uyacela ke ukuthi ke abashushisi bavunyelwe ukuthi baqhubeke nalokho ke abayimisele ukuthi bakwenze kuzothi ke abameli ke batholeke isikhathi sokuthi ama cell phone records lawo ke babheke ke ukuthi ke inhlobo yinike yobufakazi base bayahlukanisa ke nokuthi futhi ke umbuzo ekufanele ubuzweke nanjengamanje ukuthi ke ubufakazi lobu obufanelekile yini noma obufanele yini ukuthi ke buyathulwa noma ke buyalethwa ke kusona lesi sigaba lesi lana ke sibhekene nobufakazi obuphathelene nomakhalekhukhwini nokuthi futhi ke uma kubhekwa ke kuona ke lamacala ke afundiwe lana kubheka ukuthi ngabe ubufakazi lobu okubufakazi obuyibona noma ke ubufakazi uma ngabe kubhekiwe kuthiwa ubufakazi obuyinzwabethi uma ngabe kukhona ke abameli abanenkinga nako lokho kufanele ukuthi ke kulethwe ke uma kubhekwa ke okuyikona namaqiniso okwamanje ke ukusho ke lokho nenkulu ke inhlonipho ukuthi ke inkinga kabameli abathi banazo ke manje ukuzama ukuvimba ukuthi abashushisi bangabuzi imibuzo kuse ukucabangela ke lokho kufanele qala bavumeleke ukuthi ubufakazi lobu bethulwe ke phambi kwenkantolo bese kuthi ke mase bethola isikhathi sabo ke nabo ke bavezeke lokhu ke abanenkinga nako konke lokhu ke kuzophendulwa ke inkinga lezi abameli abanazo ukuthi ke bengafisiki ukuthi ngaqhutshwa kanjalo ubufakazi sikhona istatement esifungelwe phecelezi ke affidavit yaloyo osebenza kwa Vodacom uma njena ke singathi sivunyelwe ukuthi ke ubufakazi lobu siqhubeke nabo kuzofaneleke ukuthi ke abameli baphikiseke ubufakazi lobo noma babizeke nabo ababo ofakazi bazolithola ithuba lokuthi ke bahlome nabo ke imibuzo uma ngabe sesiqedileke nokuthi babizeke ofakazi akukho ke nowodwa ke kule mithetho noma ke kulamacala abameli abawafundile oshoyo ukuthi cha abashushisi abavumelekile ukuthi bangaqhubeka kwicala ke likaMehapi umnumzana uZamusipile akhulumile ngalo abekho ofakazi bakwa Vodacom ababizwa khona lapho kodwa ke babe bekhona ke abanye ofakazi kodwa hayi okwa Vodacom kodwa ke kuleli icala ikhona ke statement esifungelwe somuntu osebenza kwa Vodacom basayimisele futhi ke abameli abashushisi nanjengoba abameli beshilo ukuthi abanye bona ke bayithola le 205 abanye bona ke bathi cha abazange bayithole abashushisi bathi ke basazimisele ukuthi babanike abameli ukuthi ke babheke noma babukeke ukuthi lobufakazi lobu ubufakazi obunjani futhi ke nala uadvocate uNxumalo ehlanganisa khona ke udaba lwalama phoyisa noma ke ofakazi ababili ebeyimisela ukuthi ke ababize kanye nalolu udaba ukuthi cha into embili lezo eyingafani kodwa ke nje egcinene uthi uyacela ukuthi ke abavunyelwe ukuthi ke inkantolo abavumele ukuthi ke ubufakazi lobu baqhubeke ngabo.
Sorry, just for my understanding, when you say there is an employee or an official of Vodacom who will explain, what do you intend to
Affidavit,
convey?
yeah. There's an affidavit.
There's an affidavit?
Yes, an affidavit by
this gentleman?
Yes, the
or
employee
lady?
of Vodacom.
And he works for Vodacom?
Yes, it's a male person.
Hello?
It's a male person.
Male person?
Yeah, he has deposed to an affidavit in terms of Section 54 of the electronic...
Section 50, yeah,
15.4.
15.4, ne?
Yes.
Are you saying it was never served on the defense? That affidavit?
Well,
They don't know the contents of that affidavit.
Well, my lord, as the court would have gathered, some say they've received disclosure, partial disclosure, some say they haven't received. And I think it will serve no purpose to go back, my lord. All that we're saying is that at this point we're prepared to give everyone the opportunity to have a look at the affidavit. In Advocate Numalo's head mentions that he received partial disclosure.
Partial disclosure?
Yes, and as we've indicated, my lord, just to overcome that problem, we are prepared to give everyone this information.
Anyone want to respond to the partial disclosure story?
There is no partial disclosure that was done to me regarding this
Not to you.
Portion of evidence, not to me, my lord.
Mr. Umalo?
My lord, the partial disclosure is in respect of the fact that I've received only 6 pages. I've got 6 pages of the Section 205 records of the
Affidavit.
number. No, I don't have the affidavit, my lord.
What is the record? What do you call the record? What is the record?
The Section 205 records, where it shows that
Is
this
it in-
number,
is it-
there was
sorry,
communication.
Sorry to disturb you. Is it in the form of an affidavit?
No, not in the form of an
It's
affidavit.
in the form of what?
Of communication.
What is communication?
Communication between the number ending 821 and other numbers. And it starts from the 23rd of January 2015.
And it is how many pages?
6 pages. Start from page 8 to 13 instead of page 1 to 364.
What is in that document from page 6 to page 13?
My lord, may I be clear on this?
Yeah, because I'm not with you.
Yes. It starts from, I don't have, firstly, the affidavit of the gentleman, as the state is saying.
So this information encapsulated in paragraph or page 13, what is it? What
No, it is-
information is it?
My lord, it is the cell phone data. It is the same
Yeah,
as...
fine. I wasn't aware of that.
Yes, it
So
is-
that is cell phone data.
Cell phone data, my lord. It starts from page 8 of 374. So I don't have page 1 of 300.
Okay, wait a minute. So you've got page, you don't have page 1 to page 8.
Yes, I don't have
You
page
have-
1 to page 7.
Oh, you don't have page 1 to page 7.
Yes,
You've got from page 8
8.
to
to page 13.
13.
13 of 374. So there's supposed to be 374 pages, but out of 374 pages, I've got 6 pages. That is page 8 to page 13.
So is that what Mr. Balo is referring to, partial disclosure? How did that partial disclosure occur?
It occurred in the sense that when I came on board in this matter, I was given these files. These files, including the Cleveland case and other files for this case, the phosphorus
fine.
case 636 of 10/2014.
So you came on board on which date? After
I came on board in 2013, my lord. I came on board in 2013.
2013?
Yes.
So,
Sorry, in 2023, not 2013, I'm sorry.
yeah.
I'm sorry.
2023.
Yeah,
You
2023.
came on board.
I came on board in 2023.
What do you mean you came on board?
When I was
Instructed.
instructed, yes, when I was instructed. So I had to liaise with my colleague, Advocate Baloyi, to give me disclosure of the contents of the docket. That is how I came in possession of these files. There are about 8 files in total, but I was concentrating on the relevant files.
Yeah, ne?
My lord, for me to quote this, I was quoting this to show that the state had this information.
Yeah, fine, I hear you.
Yes, that's why I was quoting this.
Yeah, fine.
Yes.
So, is
So
that
in order
the,
for them, my lord, to prepare for their case, not to challenge Mr. Mncube now in cross-examination.
No, fine. We'll come to Mr. Ramsipidi. What, you don't have any partial disclosure?
As the complices, my lord, I do not have
Partial
the
disclosure.
And in fact, let's put things into perspective like lawyers, my lord. What Mr. Advocate Ngumalo says he's got, it's an annexure. So there must be an affidavit, and annexed thereto will be the cell phone records. So he does not have the founding or the affidavit that was submitted to the service provider to request the cell phone records. So we must understand that in that context.
Okay.
I personally have got nothing, my lord, and
Nothing, okay.
I've always been honest with this court. I don't have any disclosure of either the affidavit or the annexure thereto.
Okay, thanks. Yes, Mr. Nisi?
It's-
Any partial disclosure?
It's very interesting, my lord, that the very same thing that are actually affecting directly my client, I have nothing of those, my lord. As I've indicated to the court that the first time I heard about Cleveland issues was when the state, through Advocate Baloyi, approached me, actually us here, and said, guys, I've got a section 205 of Mr. Mncube that relates to the Cleveland case. I'm presenting to you. I think this is going to be an early Christmas for you because that is going to be very handy or
I see.
helpful in the defense of Mr. Mncube's case, my lord. I don't have nothing.
Okay.
My lord, maybe I must add that I don't have the affidavit of the investigating officer who made the request. I also don't have that affidavit, which was referred to by the state.
Is there such an affidavit, Mr. Baloyi? Affidavit.
Yes, there is, my lord.
And it's dated what?
It's dated the 5th of August 2015.
What?
5 August 2015.
5 August 2015.
Yes.
Is that the date when you received this affidavit? Or,
Yes. We're talking now.
oh, I see.
There
Yeah,
are
okay,
two
fine.
affidavits now. We're talking about the affidavit of the investigating officer.
Oh, I see.
There's also an affidavit of the Vodacom official. So the one of the from the investigating officer is dated 5 August 2015, and the one from Vodacom, as my colleague indicated, that after we accessed the cell phone records, we requested a fresh affidavit, or an affidavit which is dated 17 August 2026.
Okay, August
Just keep the-
2026.
Keep the two apart.
All right. So the state says, for instance, they're making a request or an offer or a suggestion that what if they, the state, disclosed the information which is impugned by the defense, and the defense is being invited by the state to make up its mind after viewing and assessing that information, and that their right to object is not militated against by such examination. Does it make sense what the state is saying?
My lord, I
You
think
want
this-
me to repeat it?
No, I think
Or
I
you
heard
want
a
Mr.
state.
Baloyi to repeat it for us?
I heard a state, my lord. The state says,
Yeah.
actually, our laments are a bit premature because they do have those that we are expecting them to produce in order to sort of prove the evidence upon which they want to take Mr. Mncube on. Now, the state suggests that we, as of now, we can have an access, or they can make available the entire record. They can also make available the affidavit. When I say record, I mean the record of the cell phone activities. They can also make available the affidavit of the investigating officer who approached the magistrate for an application for an authorization in terms of Section 205 of the Criminal Procedure Act. They can also make available the affidavit from the cell phone provider detailing all the processes that they went through, my lord. That's just one aspect of it all, my lord. Now, the procedural issue, and which I think is going to create a conundrum, my lord, is now we are at the defense case. And actually, before I get to that, my lord, when we held the pre-trial conference, there was no agreement between the state and the defense that certain evidence would be led through affidavits. At all material times in criminal proceedings, evidence is led through how do I call it now? It's evidence is presented in a viva voce way, orally. Now, that which the state is suggesting now is to the effect that once we give you that information that you're lamenting on, those affidavits, various affidavits and everything, then you can proceed to quiz Mr. Mncube, then on the movement of Mr. Mapungu's phone. But that's not the case, my lord, because we'd also want to quiz the makers of or the deponents of those affidavits. I may not specifically tell the state now what questions do we have, but I have a lot of questions for them. How do I ask them those questions when I'm only having an affidavit before me? And how, at what point will then the state call those witnesses for me to quiz them when Mr. Mncube is still in the box here? Because immediately after Mr. Mncube's testimony, we go to his witnesses. After Mncube's witnesses, we go to the case of accused number 4, and then we go to the case of accused number 5. Because this is the defense case. And then they close. I don't know at what point will they then lay the basis of those, the basis of them leading, cross-examining Mr. Mncube on the information that they want to disclose now. Because certainly, I will not be satisfied with simply saying, no, I've got the affidavits, then it's fine. They can proceed to cross Mr. Mncube. I mean, to say that they can proceed to cross-examine Mr. Mncube on the basis of that information that they would have disclosed now. But furthermore, my lord, is even if they say, we'll do that at the close of the defense case, after we had made an application, which would be very speculation, we'll bring an application for the reopening of the state's case, and we will then call those people to come and authenticate the information that you want them to authenticate and cross-examine them on the information that you want to cross-examine them on. The issue still remains, my lord, is, are they then suggesting that after we've satisfied ourselves about the question and stuff like that, should then Mr. Mncube reascend the witness box for him to be quizzed? That's a procedural conundrum, my lord. Because I can tell them now that that process, my lord, is going to prejudice Mr. Mncube. I have heard of no procedure where an accused person reascended the box twice, my lord. That I haven't heard. But those are the, I can hear Advocate Balo is trying very hard to say it's a practicable solution. I don't think he had all these things that I've just mentioned now in mind, my lord. But furthermore, my lord, I think the state has said a lot about the Mohapi's case, my lord. And they want to take an easy way riding on the back of Mohapi's case. In Mohapi's case, this is not what happened, my lord. What is happening here is different from what happened in Mohapi's case. In Mohapi's case, the cell phone records were led when the state led its evidence, but they simply omitted to call the cell phone data analyst from the cell phone provider. Instead, they led the evidence of the police, who had a bit of a knowledge about that information. But that was at the time at which the state led their own evidence in their state's case. When the matter went on appeal, then the accused lamented evidence. You said you'll also be leading the expert evidence from the cell phone provider, which thing you did not do, my lord. The situation as it is happening in this case, the state has closed this case without leading that evidence. Now it wants to lead that evidence when the defense is leading that evidence. I mean, when in the defense case. More importantly, when Mr. Mncube is accused number 3, who the state wants to take him on the movement of Mr. Mapungu's phone, is in the box. Are they going to suggest that Mr. Mncube must get out of the box, that they should be allowed to lead their case, introduce those affidavits through their witnesses who should have been in the box, and then re-invite Mr. Mncube into the box? That's a procedural conundrum, my lord. I don't know how the state really intends to bypass that, but those are the issues that I'll be raising and raising them very vocally, my lord. Thank you.
Yes, sir.
As the court pleases, my lord, Advocate Ministry has eloquently and brilliantly surmised the position, my lord, and especially let me touch with respect to what Mohapi says, my lord. Mohapi now is a heralded case in this country, my lord, as to how to treat data automatically generated by a computer before the court accepts that information and before the witness is confronted with that data, my lord. And correctly said by Advocate Munisi, Mohapi and others were not confronted with that evidence in cross-examination. They were confronted with that data information, called data records, during the case presentation of its case. The only lamentation was that they did not call the network provider officer, who is Petro Heineke, in that matter. And the court says, but the requirements of admissibility are fulfilled because other people who are competent have done the testimony, and you never said that testimony is not reliable. That was the answer to Mohapi and Mr. Holworthy or the other gentleman who was involved. So in this matter, my lord, the predicament that we sit on is that currently the state is supposed to resume cross-examination or to start cross-examination of Mr. Mngube. And I appreciate the state saying we were premature. They've got all of this information, the affidavits, the 15-4 application, and the 205 application to the magistrate by the investigating officer. But the question is, how do you confront Mngube with an affidavit whose deponent has never testified in this court? The two deponents, be it from the network or the investigating officer, have never testified in this court. And in the midst, I said yesterday, in the midst of the defense case, you are asking Mngube, come and sit down. The state is reopening, without even application, reopening the state's case. We are putting two officers that have made those affidavits and the person from the network to lay the basis for this. Then we'll confront you with that. You can go back to the box. That's a procedure I've never heard of, my lord. And I've always said, as a practitioner, we are called practitioners for a reason. We learn every day. If you stop learning in this profession, you must quit, my lord. But some of these things that I'm learning here, I'm shocked, my lord, with the greatest of respects. Because procedurally, we are sitting with a dilemma. As Advocate Munisi says, it's a conundrum, my lord. My lord will remember, and let me put this into perspective. When Ms. Vicky Pinky Vitili Ngem was led, she came here with numerous certifications and authorizations to show that that which she did it in terms of Acta 25 of 2002, Section 15.4 thereof, and other affidavits that closed all the gaps so that no issues of reliability will be raised, because there are affidavits that, and she also explained that this data is secured because it is hands-off. There's a term that she used, my lord. So in this instance, to say, and I'm not saying, let me reiterate this 1,000 times. I'm not saying the state should not. I'm not barring them. I don't have that power. I'm not saying they cannot confront Mr. Mngube with whatever CDRs that they want to confront him with. But it's the procedural aspects that I'm jumping up and down about, my lord. As the court pleases. Those are my submissions.
Any other thing you want to say?
My lord, may I start by saying that the burden of proof in criminal trials.
The what?
The burden of proof in criminal trials has never shifted. It has always been the duty of the state to prove the case beyond a reasonable doubt, and the accused person has to show that his defense is reasonable, probably true. I don't know when the state is referring to witnesses that the defense may call. Which witnesses are those? Point number 2, the issue of arguing the authenticity of the records, that we argue the authenticity of the records during the
Mr.
Yeah, yeah,
An
he'll interpret.
An urgent need
For,
for a comfort break, my lord.
oh, I see,
Yeah.
okay. You want us to adjourn now?
No, it's Mr. Mncube, my lord. He's just asking to just go down, my lord.
Okay, what's your time now?
It's 5 to
5 to 1. So should we adjourn or what? Or for the day?
I suggest that we come at 2 o'clock.
2 o'clock?
Yes.
Okay.
before
Yeah.
the long adjournment. Firstly,
Yeah.
my Lord, I wish to be understood in respect of the disclosure. My Lord, the information that I referred to, that is the Section 205 records, I don't have the affidavit, but I must mention that it was in another case docket, which is not related in respect of the matter that you are dealing with in
Yeah.
court. It was in respect of the Alexander case docket, not even in the Cleveland case docket. That is where I got this information. So, which is also likely that my colleagues, my other colleagues will not have this information. As to how I got this information, I don't know. But I wish to stress that it has nothing to do with the matter beforehand.
Yeah,
It is
okay.
for Sora's case 1636 of 10,
Yeah.
2014. And I must re-emphasize, my Lord, that I still stand by my submissions. In fact, even the state has indicated that the affidavit of the investigation officer is dated the 5th of August, 2015. And the Section 205 data for the number of the witness, Mr. Mngube, was used during the proceedings. I wish to anchor the submissions by my colleague, Advocate Mnisi, when he says, Advocate Baloyi approached us that he's got a Christmas for us. He's got the Section 205 data or information that will assist us, that is the defense, in the conduct of its case. So that Section 205, which is Exhibit G1 of the record, does not form part of the Sora's case 636 of 10, 2014. It was in respect or filed in some other dockets, and it was used in this main case that you are dealing with in these proceedings. So I stress the point, my Lord, that the state all along had this information, because they've indicated that the affidavit by the investigation officer is dated the 5th of August 2015. So they had ample of time to go through whatever files and whatever evidence, my Lord, that they wanted to use in proving the case beyond doubt. And secondly, the issue I wanted to address, my Lord, is that it has always been the case in our system, the jurisprudence, that the burden does not shift. It is the duty of the state, my Lord, to prove the case against the accused person beyond reasonable doubt. And the accused does not have to prove anything. If his version is reasonable, probably true, he has to be acquitted of the charges. So I don't understand the submission by the state that we will then call witnesses. Which witnesses? Because it is their case. They must prove their case beyond reasonable doubt.
Yeah.
Thirdly, the issue of authenticating the documents. We cannot authenticate the documents, my Lord, later during the judgment. We need to call, or the state has to call witnesses to authenticate the information that they want to present. I don't know, my Lord, why the state is at pain to consider reopening the state case later after the defense of Mr. Nduli, accused number 5. Open the state case and present this evidence, because it will be unfair where one expects Mr. Mngube to stand down and go back in that box. Witnesses are called, they are cross-examined, then he comes back. That will be a futile exercise, which will render the trial into disrepute. Thank you. Those are my submissions.
Okay. Yeah.
Thank you, my lords. My lords, by operation of the law, I'm not allowed to accept any documents from the state during the defense case. Even if the court is inclined to assist the state. But
This court is not inclined to assist anybody. You mustn't make such statements.
Even
inclined
if,
to assist.
can I rephrase, my lord?
No, please.
Even if the court is inclined to allow the state to introduce this evidence, my problem, my lord, is that that cannot happen in the middle of the defense case. Until the defense case finishes, then the state can indicate its intention if they want to bring the application to reopen the state case and bring this information. Those are my submissions, my lord. I'm not allowed by operation of the law to consider any new evidence that has not been placed before this court in the middle of the defense case.
Okay.
That's the court.
Let me just correct one misconception that we intend to ask that Mr. Ngube stand down and we call witness. We never said that. I don't know where my learned friends really get that. And that demonstrates why we should be allowed to proceed so that we are not second-guessed as to how we intend proving the affidavit. We said we'll lay the basis for that. And as to what Mr. Ngumala has said now, Nima talks about the rebuttal of the evidence. We never said that the defense is expected to call witnesses. It will be up to them as to how they deal with the witness, with the evidence. We just wanted to correct that.
Okay, thanks. Is that the end of the submissions? Okay, let's postpone to Tuesday. I'll tell you, Monday, we are attending the funeral of a colleague. She died and she's being buried on Monday. You know Miss Mokotla?
Mkhotla, the one in the SCA,
Yeah.
the lady.
Yeah? Are you saying ladies don't die?
Fikile, I think her first name is Fikile.
Hello?
I think her first name is Fikile.
Yeah, Figile Mokotla.
Oh, that's...
Yeah, apparently she deceased yesterday. So we'll come back on Wednesday. Sorry, on Tuesday. Tuesday, please, because there's going to be some function and so forth and so forth. Okay. Yeah, thanks. Well, Jen?